GDPR and AML, what can go wrong? Quite a lot of things actually, so we're gonna take a look at this today. I did this presentation yesterday in front of quite a big audience, and there was a lot of good feedback, so I thought, okay, let's record it, so it will be hopefully quite a lot of interesting learnings from this. So just a quick recap about me. So I'm a privacy expert, a data privacy expert. I have over 20 years experience on the matter. I advised the French Prime Minister administration during the negotiation of GDPR. As an expert, I trained probably half of the CAC 40 data privacy officers at the group level, as I've been in this field for a very long time. And I founded legiscope.com, which is a GDPR compliance software that tries to automate as much as possible the compliance processes. So today we are going to talk about basically two problems that are related to GDPR compliance and AML. But really the first point I would like to address is the first problem I see most of the time in organizations is that they don't really understand why you are doing GDPR compliance in the first place. So, of course, there's a side where we all think about, regulations. We have to apply regulations, and it's a little bit the boring side of the work we have to do. There's rules, we have to apply these rules. But actually, there's often a lack of understanding of why they are here in the first place. And really, the point of GDPR is not the EU Commission didn't gather a group of experts to think about what's the most complicated regulations we could come up with. But actually, the reason of these regulations, and in France it's really over 40 years old, it's really because the regulation aims at protecting data subjects, so any natural persons we're processing data, from the risk related to the processing, the IT processing of their data. So you really have to think that there's quite a lot of risk related to the processing, to data processing, personal data processing in IT environment. And this is really the reason of this regulation and all the rules that exist in the first place. So one lesson that really took me 10 years to understand about GDPR compliance is that if you look or privacy compliance, so if you're new to GDPR regulations, really understand that it's the same regulation we're applying since 1995 more or less. But GDPR really added important fines to this regulation because it was not dissuasive enough. The fines were not dissuasive enough. So that's the really, from operational standpoint, it's when you have to apply privacy regulations, we're applying 80% of the same things we were applying for the last 20 years or more. So what took me really 10 years to understand is that when you break rules from GDPR standpoint, most of the time you're breaking trust between your customers, your employees, your data subjects, and each rule that is set in the GDPR is really designed, and it's really well thought. It's really designed to ensure trust throughout the whole data processing chain. So this means that, for example, if I were to create a newsletter, and if I ask your email, you would think, okay, that's okay, makes sense. But if I start to ask you your personal address, and if I start to ask you your personal identity code, or your social security number, or any other data, your religious preferences, then you would think that something's really wrong. Why do I have to give this much data for such a simple newsletter? And what you would feel as a person, that there's some distrust that comes with this. And it's exactly, and if you take, this is exactly, would be in this case a violation of Article 5, so it's pretty simple idea, which the controller has to collect the minimum of data needed for the processing. And so in reality, if you take all the rules that are set by the GDPR, each and every one of them is pretty much about keeping trust and ensuring trust throughout the whole data processing chain. So what we're trying to do when we're doing GDPR compliance, we're trying to avoid damage to data subject, to their data, to natural persons, because of all the risks that are related to IT processing. And more generally, what we're doing is we're creating rules, a set of structure, and we are creating rules and structure inside the IT, inside the IT structure and IT processing or IT systems more generally. So you will see already throughout the presentation what it means to process data without GDPR compliance, what the end result will be, and I hope it will give you a lot of thinking. It will make you think a lot about how useful it really is, because GDPR arrived after a very long series of catastrophes and disasters, and we're going to take a look at a few of them so it's very clear. So GDPR compliance is absolutely not about cookies. It's actually a directive from 2002 that really should be updated by now, because I don't know how much time we are spending collectively pressing on cookie pop-ups. Someone probably should keep account of this, but we're probably in the millions of hours, and it's a real annoyance for everyone, privacy experts first. So it's not about cookies. It's also not about adding a data privacy officer, although it can be a really good thing. But I just want to give you two examples of the French CNIL, the National Control Authority, who sanctioned two different companies right after, I think it was June or July 2018, so right after the GDPR entered into force. And two companies had a data privacy officer. They were very happy. They just nominated their own data privacy officer, brand new, no training, but to their eyes didn't really matter. And so what this data privacy officer did is that they sent quite a detailed extent of the extent of the processing that was done by the company, and it was of course done completely not in compliance with GDPR. So of course when the National Control Authority received this information about this data processing, of course they started to control immediately, and they realized in both cases that the company was acquiring prospect data in very large amounts. So in the first case it was 14 million prospect data, and the second case was about 42 million prospect data, and in both cases they were acquired without proper consent or without proper legal basis. And in these two cases the National Control Authority required all the data to be deleted. So I don't know if you can understand the extent of the damage it can do for a company to acquire data unlawfully. But for sure, if you're thinking just adding a DPO will solve the problem, it's really not the case. Actually, it can make the situation worse in some cases. For sure, having someone trained is, in regard to GDPR regulation, it's probably the best asset you can have in a business. But yeah, training is really needed to understand the regulation. It's also not about adding consent everywhere you can. And just we can take an example of a company who was fined, especially in labor law, in regard to labor or employment law, because they added consent, and usually we consider that in employment matters, it's not really applicable, or it could be, but it would be difficult to apply. So and here in this case they got a 150,000 euro fine for this. But the most part is, if you're working on this, if you're concentrating on these matters, you're actually not doing GDPR compliance at all. And the worst part is you're not lowering your risk. So this is what really matters. And these are common mistakes. The first one is you're not assessing the risk that processing of personal data will generate for your customers, and the second is you're not working on to lower this risk. So as a result, you still have a lot of risk in the business, and not a lot of work is often done. From what I see on my side, as an expert in this field with 20 years experience, is that companies waste way too much time spending time on internet looking at what should be done, and it's usually not a good advice, and it's usually not operational at all. So sometimes it's just better to go for a training and just do what's actually really needed and be efficient with this, instead of wasting time and just trying to figure out what needs to be done. On the second side, we're going to touch, of course, more about AML in this perspective, but just what matters here is really to understand where you need to put your energy because and your resources, because this is going to make a huge difference in terms of risk that still exists in a business and how you can mitigate or eliminate this risk, and where to put your efforts, because at the end of the day, what you need to do is to conduct compliance actions, and this has a huge impact on the results that you will get. So the second point is really not understanding the legal framework, and what I'm going to talk about is what really leads to real fines. If you look at the GDPR, there's quite a lot of rules and 99 articles, and it's quite a big regulation to digest, but not all rules will lead to fines, especially in cases where there's absolutely nothing at stake with a data subject. There's no risk for them. So what I'm going to talk about here is really maybe 5 points, or the most important points that you will find in most of the fines. So if you take, for example, the last 50 fines that were the last 50 fines, you will see that these points are always there. I would say maybe 98% of the time they are there. So this is really from risk perspective. It's a practical operational view from risk perspective, what you should be doing first. And if you haven't worked extensively on these problems, you should spend some time on it. Maybe the first point is not understanding the risk of fine, but this is quite more clear now with time. In 2018, it was not so clear for quite a lot of people that GDPR would actually generate quite a lot of fines. It's actually baked directly into the GDPR, so there was not a lot of legal discussion from this point. But still, there's some people have some discussion from time to time. So the point to understand is that GDPR is a great tool, offers a great leverage against you in your current conflict. So the first thing you should take a look at is what are your current conflicts, and what you should work on is to lower the risk of this conflict being able to degenerate on GDPR conflict. Because I had a talk yesterday with a lawyer specialized in employment law and in Europe, and she was saying that the first thing they think about when they have an employment conflict is GDPR regulation, because it offers such a great leverage for an employee, a conflict with an employee, or more generally conflict with customers, angry customers, that it's really a great tool to against you. So another point to understand is that what I was saying is that it's really baked into Article 83 that each supervisory authority shall ensure that imposition of administrative fine in each individual case shall be effective, proportionate, and dissuasive. So each fine has to be dissuasive enough. This is the reason, and it's really written, black and white on GDPR. And this is the reason why there was no discussion about will we get big fines. Of course, we will get big fines. It's already written clearly, and this is the reason we got, for example, Amazon got 742 million euros fine, or Instagram or Meta had also 400 million euro fines. So if you take a look at the last fines, for example, from the French CNIL or from other control authorities, of course, fines has to be substantial enough to be dissuasive. So you look at, for example, Discord, they were fined for keeping data or not deleting data, so 800,000, 20 million for Clearview, 1 million for Total, another 1.5 million for another company in medical sector, 90 million for Google, 60 million for Facebook. And the fines are, it's really one point that's important, is that fines are here, and they're also here to protect, to make sure that companies cannot do risk, just a risk management with GDPR regulations. And that's one big change, that's one structural change. Before the regulation of, on the directive 95/46, basically most companies ignored this regulation, or did really a little bit or minimum. I would say in most cases, I'm not saying in all cases, but in a lot of cases, company quietly ignored this regulation because there was just no cost related to that. GDPR really changed completely the structure of this, so it's a new paradigm where actually you can't ignore this regulation and you have to apply it at least to some extent that it doesn't cause damages to your own data subjects. So sometimes another aspect that's not really well understood about non-compliance is that your own non-compliance, and for example, this is a slide I wrote 20 years ago, your own non-compliance will actually make things worse for you in some cases. Today we see a lot of ransomware attacks that are using the fact that some controllers didn't put enough security measures, and so you have also sometimes this double sword, where you have a first hit by a ransomware, and then you have a second by the National Control Authority, who, for example, in this case, issued a monetary penalty of a professional service firm after a ransomware attack of about £100,000. So it can be quite painful. So let's go, maybe now with this consideration in mind, let's go more into AML questions and GDPR, so we can see what are the main problems, or some of the main problems in this area, and the things that really should be concentrating on. So one of the big problem we see, I would say in most cases, or maybe all cases, is that controllers do not delete data enough. So data is kept, personal data is kept for way too long, and there's no automated process to ensure deletion of this data. So this is one huge problem if you want to just to work on the 5 worst problems of GDPR that would lead to find. This is probably one of the most important. So let's just take a look at Article 5. So personal data shall be kept in a form which permits identification of data subject for no longer than it's necessary for the purpose for which personal data are processed. So it's a principle of storage limitation, and often there's like different levels to this. The first one would be, are you really clear about how long you're keeping data? And you have to have a clear vision about each of the personal data processing activities that your organization has, and ensure that, okay, do we have a specific storage limitation, a time frame, and is it really enforced in the company? Now, once you've done this for all processing activities, which is quite a lot of work, then you have to take a little bit deeper look at is your storage limitation practice coherent in regard to your legal basis? So, for example, this is where we have a lot of moving parts in GDPR, especially in regard to the purpose of processing, because the purpose will define, for example, the storage limitation time frame, which will also define the purpose will also define the legal basis. And also this will define who can access to the data. So there's quite a few moving parts, and this is quite an important one, because, for example, if you require consent, then the data is processed up until the consent is withdrawn. So if you process the data based on legal obligation, this means that it will be processed until the legal obligation is until the duration of the legal obligation. So there's quite a few thoughts or a few things to think about in this regard. The next question is I would have for you is, are you really deleting your data, and did you check or did you just ask? And this is really a question I got from experience. I will tell you quite an interesting story about a company who was under control. Of course, I will not give you details about the story, but basically the company, the French National Control Authority controlled an organization, and they detected that they kept quite a lot of prospect data. So this was, of course, after the GDPR entered into force, and so they noted quite a lot of points. This was one of the points. And the company required lawyers, and lawyers contacted me and asked me, could you please take a look to make sure everything is correct, everything is well done, so we can do a second check. And I came to the company to do a second check and to make sure everything was well done. And when I arrived in the headquarters, I met with the data privacy officer, and I said, okay, let's look at this point. So is the data really deleted? And he said, yes, all the data deleted, everything is fine. So I said, okay, so I'm going to check this. So we're going to go in the databases directly, and we're going to make a SQL request to make sure that there's no data anymore. And he said, no, it's not needed. We can just, I can guarantee you it's done. It's for sure it was done. There's no problem in this regard. And I said, yeah, but my job is to verify, so I have to really take a look at this, and we have to check that it's really well done. He said, no, it's not necessary. We're losing time. Why are we doing this? It's also very complicated. We have to go to a specific room. Only person can have authorization. And I'm like, I understand, but I'm here to check, so I'm gonna do my check, and that's the end of it. And so after a lot of protests, so okay, we're in France. After a lot of protests, finally we get to this specific room with this specific computer and this specific terminal, and this data privacy officer starts to make a request. And of course, I had pretty much an idea of what would be the result. And so he makes his request, and he found that there's about 172,000 records of prospects that were not deleted. And he just realized this, and he's like, no, but it's not possible. I asked the data to be deleted. And this is a story that I hope you will remember, because this happens all the time. It's not the first time it happened. This is the reason what happens with how you build your own experience. But this happens a lot of time, where the problem is thrown to someone else, and someone else is so busy and there's no oversight. And then you end up in a control, which is a complete disaster, because if you within a control certify that yes, the data was deleted, and the national control authority makes a request and find out that it was not deleted, then for sure the amount of fine you will pay will be really very important. So in this regard, you really have to check, and don't hesitate to check directly in the databases to get SQL request, or to get some help from IT department if you need. But don't just trust it's done, verify it's done, because these are very important elements, especially during a control. But even if you're setting a process to make sure the data was well deleted, it's good to check this out. So other points you can think about is also, are you keeping the same data in other parts of your IT system, in particular in backups? So it's also the way to organize backups. It should also be giving a little bit of thought. And just to give you an example, if I take a look at the latest fine from the CNIL, the French CNIL, you will see that the latest one was, at this time of the recording, was about Discord, who didn't delete data. So of course, it's an important point. The second element would be to collect too much data. And I have to remind that the principle of Article 5.1c imposes that personal data shall be adequate, relevant, and limited to what is necessary in relations to the purpose for which they are processed. It's called data minimization. It means simply that you need to collect as minimum data as needed. So there's one problem that's pretty classic, and especially in AML data collection, that might be a huge huge issue for controllers. This is what we call free forms. So in France, this problem is pretty well known. Basically, we call freeform when you can add any type of data related to a customer, and there's no basically limits or no structure, no IT structure in regard to this. So your own employees can collect and add basically anything they want, and it's quite a big problem, because without structure, the reality is they will end up adding anything. So there's really two explosives combination. You add a big amount of subjective assessment about persons, about natural persons, and you add this free form, and this is the result you will get. And I'm going to just take one example of 2007, so it's quite an old control that was done by the French CNIL, but it still is illustrates the problem very, very well. So in this case, the CNIL was doing a control in a case of a company who was collecting CVs and for employment purposes, and so people could go on the website and fill up some forms, add their CV, and then there was some kind of evaluation that was done on the persons, and there was some specific code. That doesn't really matter. But what's interesting is you had this formula which is you have one evaluation of the data subject of natural persons, and you have this free form, and when you combine these two in big numbers, you're gonna get the types of comments that you will see. So they requested an extract of all the comments that were added in regard to people, and the following comments could be identified: subjective comments on the behavior of people, not credible, slow snail, social case, disaster, liar and unreliable, bad, hygiene problems, smells, too boring, comments referring employees theft in a store, was suspected of theft in 2003, could be a thief. Or comments related to employees' health, disappeared due to depression, hospitalized, depressed, pregnant, person without teeth and who drinks, alcoholism problems, suffer from a cancer and will no longer be able to work. Comments about employees' negative personal or familial relationship, M's girlfriend, unreliable, no longer lives with her husband, G's wife. Or comments related to a court procedure in progress, through as much work as possible, he sued our company, or brought our company to the court. Or comments mentioning a new professional situation of the person concerned, retired, has found work, enters the army, or is unemployed but prefers not to work. So yeah, this is very classical example, and you will get this pretty much all the time. And really the problem is not that you can't do a subjective evaluation of a person. You can. It's not a GDPR problem. The problem is that you're collecting, in this case, that the controller is collecting way too much data. For example, we can have an evaluation of for example, the presentation, physical, how a person is presenting, and it can be an evaluation from 0 to 10. But it's not needed to collect data related to a person's teeth or whatever. In regard to this, it's not needed data. So how we can handle these problems? We can replace these data points by radio checkbox and radio buttons on the form. We can have an evaluation from 0 to 10, 1 to 10, good, very good, bad, excellent. So this allows you really to limit the amount of data. And for in the cases where it is necessary, there's a whole training on this. I could spend half an hour on this point, but basically it's really necessary if you need if these free forms are really needed, and they can be in some cases, it's okay, but you really need to provide specific training for the teams who are writing this data, and to do yearly review and organize it and structure, because otherwise you're going to get this problem at some point. And if you have free forms, you should really audit them and take a look at what kind of data you have, because I can guarantee you will have some interesting surprises. So of course, within AML logic, CDD, for example, you could of course segment in regard to risk. So you could have level 1, level 2, level 3, and segment the data collection based on this risk. And of course, add enhance security measures when you find that there's more risk or there's more data collection in regard to this. The next point that we have is also not having a coherent legal basis. So there was a lot of discussion about AML obligations, which legal obligation, which legal basis, so Article 6, should we use? Of course, there's a legal obligation, so this actually provides the controller a huge umbrella of the law. It's a huge protection to be able to collect data in regard to this, and to collect the data that's needed in regard to fulfill the legal obligations. Why? Because it allows you to collect this data and or imposes you to collect this data, and it removes quite a lot of questions, because it's not, you're not collecting this data for your own well-being, let's say, but you're really collecting because you have to. And so it removes quite a lot of problems we usually find in when we look at the fines more generally, which, for example, companies collect all data possible. Marketing departments, they like to collect as much data as possible for their own benefit. And in this case, having the legal obligation as an umbrella, it offers really a lot of comfort in regard to this. It removes quite a lot of questions you might have in regard to this. So other question could be, could we use public interest? So this is more legal discussion. I would say probably it's not such a good idea, because it opens also the right to object, and the data subject can request the deletion of his data. Of course, there are exceptions to this, but the overall logic is not so great. I don't see a valid reason to use this. Maybe some really specific cases you could think that this could apply, but for the most cases they should really stick to the legal obligation. There's also been quite a lot of discussion about legitimate interest of the controller. My question would be, why you would do this, why you would really use this legal basis, and if you really want to do this, did you do a balancing test? So, for example, on RISC we have a process to do a balancing test, and it's a 4-page process. So if you already have a legal basis that's clear, that's a legal obligation, why on earth would you impose yourself a 4-page documentation specifically for this, and that's not even sure that you will meet your requirements. So personally, I love to read privacy policy on the weekend, but for most people, I would say it's just a bad idea. Next point is, once you have your legal basis for your data processing, so you can have quite a lot of data processing related to AML here or there, but you have to understand the impact of the legal basis on, for example, how long the data can be kept. So if it's a consent, it would be, more generally speaking, it would be until the consent is withdrawn. For example, for a newsletter, it would be until the consent is withdrawn, and then you have to delete all data related to this. If it's for the contract, it would be until the end of the contract, plus the statute of limitation. Usually we add these two deadlines, and the obligation, of course, would be the time of the obligation. It will also really define who can access the data. So this is what I'm referring to when I say there's a lot of moving parts, because you have to think about your purpose, and then you have to think about how long the data is kept. And then you have to think about who can access the data, and also all justifications related to this. So, for example, if you're doing AML work and you're collecting data in regard to this, so you would use the legal obligation as a legal basis. This means the marketing department cannot have access to this. Why? Because you're doing this for legal obligation. And so the data collected for this purpose has to be restricted to this purpose. Also, you have to think about all the justifications you will need in regard to accountability. For example, you need a balancing test, you need proof of consent, the detail of your contract and obligations, etc., etc. So the legal basis is quite important point. There's actually 56 pages of fines just on Article 6 on the GDPR enforcement tracker. So legal basis is quite important, and you have to see that consider also that not all fines are on the enforcement tracker. So it's just one element that's given. It's just good work that's done by a private company, but it's not a public. It's not done by a public sector with all the cases and everything. So probably you could add probably double amount of this. So it's quite a lot. The next part would be bad management of the data processing chain. So I'm not going to get into too much detail because on this point I could speak already one day about this, but there was just a presentation right after my presentation that was just specifically about this point, so this is why the reason I kept it very short. But just to say a few things, in my experience there's two problems in regard to this, three problems. The first one is from time to time there's not a lot of thinking in regard to the data processing chain. Who, in the sense of the GDPR, who is controller, who is processor, and do you have joint control? Usually a few simple questions, but from time to time, when you look at your processors, I can say that their contract, Article 28 contract, usually it poses some problems. So, for example, I have cases where actually a processor was writing in his term of service that he was actually a controller. So that's quite a huge problem, because it means that he can do whatever he wants with the data you're collecting for your own purpose. So these things are not, of course, for serious processors. Often there's quite a lot of thinking that's done, but if they haven't really worked their GDPR compliance, you will find quite a lot of mistakes. In my experience, be prepared to have at least 40% of processors that are not completely clear about what they're really doing. And for example, one thing that one find that was quite recent was some health data. So it's another example about another sector, but it illustrates really what happens regularly in IT. So basically what happened is that the company lacked IT security measures and shared data, exported some data from one of their customers, so they were a processor in this case. And what happened is that they just put it on FTP server without any protection at all. And of course the data leaked, and so there was a question where it leaked from. But of course putting all medical data on an FTP server without any protection whatsoever, so your customer can extract this, it shows that there's deep deficiencies about data processing, and that's actually the reason we have GDPR, is to avoid this kind of cases. So of course there was a control by CNIL, and there was a fine, and when you look at this case, there was no contract, Article 28 contract, so the data privacy agreement. And so this is quite I would say quite a regular problem. So what I see also is that the companies do not have a system or processes to evaluate their processors. There's just a set of questions you need to ask. It's not very complicated, but you need to do it. And what you will see in most cases, that either processor did the work and did a minimum amount of GDPR compliance work. This means that they have a good agreement, they have a standard agreement, they talked a little bit about GDPR on their website, and you see some quite reasonable questions in terms of IT security. You see some communication in regard to this, and they did the work. It's either they did the work or they didn't, and so there's in most cases there's not much in between, because it's really hard to hide the fact that you haven't done the work. It shows pretty fast, and so also for your company, if you haven't done this work, you are for sure losing a lot of sales, because often when big companies are looking for smaller companies' services, data privacy officers do an assessment of the level of compliance, and often you will never hear about it. But so that's also a point. So the last point is no IT security. As you saw, it's a problem. In this case, it was a problem for processor, but it's more generally a big issue, and that really leads to fines. So if you're doing specific development, IT development on your own, really you have to really put some hard measures in place. For example, do you have DevOps practices in place? Do you have DevSecOps practices in place? When was the last pen test you did? And did you put multi-factor authentication everywhere you can? It's very often easy to say, okay, we will do this internally. We will ask one of our developers to build some internal application. And it's nice, but actually to do it well, to do it accordingly to, especially if you process a little bit of sensitive data, actually there's a lot of costs related to GDPR compliance, and very often these costs are not very well understood up until you have a problem. And then you understand that actually doing internal development might actually, with GDPR compliance, actually comes at quite a huge cost. And this cost needs to be just well thought before you do. My advice would be really to take a look deeply on this. Is it did you factor all the costs related to GDPR compliance that will appear at some point? And then, for example, there's a lot of different points. What encryption algorithm are you using? Do your password policy comply with the national control authorities? And the CNIL has done quite an interesting job about this. I just want to point you one tool that's really useful that you can use. The French CNIL did a really extensive and very interesting work about IT security. There's a lot of different points you need to address. If you comply with this guide, and you probably can Google translate it and get most of the most important point about it. In this case, I guess you would be quite maybe not top level, but you would eliminate quite a lot of risk if you've done this. If you've done all the recommendations, and they have quite a list of elements, what not to do, what to do, and it's quite an extensive thing. So take a look at this IT security guide, and it would be really helpful to make sure that your AML practice, how you're collecting data, how you're securing it, is really up to date in this regard. So I just want to give you two stories. The first one is H&M, who was fined about 35 million euros. So they did really good work to cooperate with the German Control Authority, and probably the fine could have been doubled if they hadn't. So they really were very dynamic in this regard. So we can take a look at this. So if you think about H&M, it's a worldwide employer. They had over 150,000 employees, and that's a lot of HR experience. When you think about it, it's they're managing to make billions or hundreds of billions of dollars every year, and they figure out how to recruit people well enough to manage to do this. It's quite an achievement. However, that being said, in 2020, the Personal Data Control Authority discovered that H&M was collecting and keeping very detailed records about employees' health conditions, including medical diagnosis, as well as religion and private life information. So I don't know if you can really imagine what it means in practice to have your HR service request your medical diagnosis when you were on absent leave, but to put people in this situation, it will create not only it will with time break trust with the HR, what they're doing with this data, why they are requesting this data in the first place. But also it puts employees in a horrible situation if someone has some medical condition that really doesn't want to talk about it with anyone. It really puts a lot of psychological pressure on employees, and the question would be how you can let something happen that is so big in Europe, and in particular in Germany, where we have extremely strong data privacy standards and everyone knows about it, and Germany was one of the leading countries with France to create privacy regulations. And especially Germany, we know that our German friends are very structured, and they have a strong reputation for structure and excellence in this regard. And so to see something like this happening at this level, it's such a gross violation of GDPR that it's really important to understand that, yes, without any structure in place, companies will end up storing anything. And the question might be how did they end up there? And what probably happens, they had employee absences manager were requesting more and more data, and we need proof and justifications, and at the end of the day there was probably no oversight, and they were just trying to solve a problem without understanding all the consequences of what they were doing at the time. And so this is really the role of a GDPR officer, is to create a structure to avoid mishandling data and breaking trust and here with employees, because at the end of the day the company will not develop very much, will not grow very much with a huge level of distrust within the company itself. So it doesn't create any value for anyone. The second case I would like to mention, it's the case of a notary. So I wanted to mention the case of a big company. Now we can take a look at a small company. And this is a case of 2009 where a notary office had a lot of very detailed records about their debtors. And the CNIL was informed and controlled the notary office. And in their records, they found that husband is a drug addict, debitor's child has Down syndrome, spleen and kidney cancer, is in jail, is divorcing because husband is in prison, old and hysterical. And so the CNIL in 2009, so GDPR was not into force, but still it was at the time excessive data. They request this data to be completely deleted, and the notary office agreed. They said, of course, it's unacceptable. We don't understand how this data ended up there. It's very bad. We will correct everything. And 3 months later, the CNIL does what they do often, is that they came back and they did a second control and requested again an extract of the records. And here's what they found. Husband is a +++ addict. Debitor child has +++ syndrome. Spleen and kidney +++ is in +++, is divorcing because husband is in +++, old and hysterical. And of course, they were fine. And you can think about it. No, how is it even possible to get into such a solution? How notaries who are public officers in France and who are legal professionals, how they can let something happen? It makes absolutely no sense. And it is true, it makes no sense. And the question maybe more generally is how this happens. And probably the notary office send the problem to an external IT company, and the IT company send the problem to a developer. Please replace these bad words. And it's exactly what the developer did. He replaced these bad words. So no one checked the end results. It's no one's problem. There's no accountability, no project manager. And this is when you think about your AML practice, collecting data, managing data, ensuring all the legal obligations, is that GDPR is really a set of rules to prevent chaos, to prevent IT chaos. And that's maybe the most important learning you can have from this presentation, from my experience, is that there's quite a lot of problems that will appear, or at least that were concentrated in the GDPR. And the reason we apply these rules is because at the end of the day, if you don't give a proper structure to data collection and which processor has access to the data, at the end of the day, it's going to end up in a complete chaos. And this is really what GDPR is trying to prevent.